will be presenting the argument today.
All right, thank you and welcome.
May it please the court, counsel. Since 2008, roughly 7,000 Iowa women have exercised their fundamental right to an abortion through Petitioner's telemedicine program, which allows women in rural areas to have a safe, non-surgical abortion early in their pregnancy. This rule would end that program. Petitioners brought a number of 17A claims against the rule, both constitutional and arbitrary and capricious, which the district court rejected. I will be focusing today on our 17A constitutional claims because what sets this case apart from nearly all of the 17A cases this court hears is that a fundamental right is at stake. Without conducting any analysis of what level of protection the Iowa Constitution affords to reproductive freedom, the district court adopted a watered-down version of the federal undue burden standard, a standard wholly new to Iowa law. But the Iowa Constitution and this court's jurisprudence require more. In particular, this court has a proud tradition of independently interpreting its Constitution to promote the liberty and equality of Iowans. For this reason, petitioners urge this court to join the high courts in Minnesota and other sister states in recognizing that abortion is a fundamental right protected by strict or other heightened scrutiny.
Counsel, isn't the Minnesota Constitution different in that it has a right to privacy, wording that's not found in our Iowa Constitution?
No, Your Honor. The Minnesota Constitution actually is very similar to the Iowa Constitution, and if you read the high court's analysis in that case, it's not rooted in any textual difference from the federal Constitution. It's rooted in that state's tradition of zealously protecting individual rights, and it's a very instructive case because it's very parallel to Iowa's tradition, including during the slave era, a more progressive position by the state's high court. So it's quite analogous, and a number of those constitutional, of those abortion rights cases from other states are quite analogous to Iowa's constitution and tradition.
Are you saying that the rule would pass the rational basis undue burden standard, so it's necessary for us to adopt a strict scrutiny? Or does this rule even pass the undue burden rational basis standard?
We are not at all, Justice Wiggins, saying that this rule would pass rational basis undue burden, at least not undue burden. The problem with the undue burden standard, besides the fact that it would be a new standard under Iowa law, is that it's been subject to different interpretations in the lower federal courts. But we believe that that standard, independently applied by this court with teeth, with substance, would absolutely require this court to invalidate the rule.
Should we apply, when we apply a rational basis test, if that's all we're going to apply, do we apply it under the federal standard, or do we do our state standard where we actually look behind the reasons?
According to this court's own jurisprudence, it would apply the state standard and really actually look at the evidence and not just ask whether there's some, as the Fifth Circuit in Abbott says, rational speculation that would support the rule. So even under this court's equal rational basis review, this court would look at the evidence, and here the evidence clearly shows that this rule is irrational.
An argument in your brief that there's a violation of the rational basis test. I see there's a lengthy strict scrutiny argument,
right,
and then there's an undue burden argument. Is
right.
there? And there's an intermediate scrutiny argument.
Right.
I don't see a rational basis argument. Am I missing something?
That's true. We did not argue it in our brief here. We did argue it below, that even rational basis, as this court applies it, would require a hard look at the evidence.
Could I ask you a factual question? Judge Farrell seems to indicate in his ruling that this particular telemedicine medication abortion procedure is unique to Iowa, that it's not performed in other states. Is that correct?
It's actually not, strictly speaking, correct. There is a program in Minnesota, but it certainly is true that it is not happening across the country.
Why don't you discuss a little bit the federal case law, just to illuminate the issue. You've got the Abbott case, which you characterized, I think, as a watered-down undue burden case. Then you have the Humble case in the Ninth Circuit, which seems to me to take a rather different approach to the term, quote, undue burden. Why don't you share with us, if we adopted an undue burden test, why I take it the Ninth Circuit approach is preferable to the approach in Abbott upon which the district court relied?
Absolutely. The problem with the Fifth Circuit's approach in Abbott is that it allows huge burdens to be imposed on women without a remedy. For example, in that case, women had to travel, over 100 miles just to access care, and evidence is clear that that will prevent some women from having an abortion, and it will delay some women. So that's why that standard is really not sufficient to protect what is a fundamental right. The approach that the Ninth Circuit and the Seventh Circuit in Planned Parenthood versus Van Hollen, and we've directed this court to a very recent Alabama district court decision, that as you mentioned, the very different approach that they take is, I think, sort of 3 points. One is that the court takes a hard look at the state's evidence. If the state restricts abortion and they say they're doing it to further women's health, you look at the actual evidence to see whether this this restriction will further women's health. And you have to take into account that it's going to delay women and that abortion is safest earliest in pregnancy. The second point is that you look at the way a restriction interacts with what the Ninth Circuit called the lived experience of women. You have to look at the fact that most of these patients have child care obligations, their parents. They have, many of them are living in poverty, they have limited transportation, they are working low-wage jobs with inflexible schedules, so you can't look at a restriction in a vacuum. You have to look at the way it interacts with other obstacles in women's lives to burden them, to prevent them, or to delay them. And then the third principle is that you don't just look at the women who are denied an abortion altogether. You look at the range of harms that befall women, and that's what we've tried to present to this court. The health risks from a delayed abortion, the loss of autonomy that comes from being denied your only non-surgical abortion alternative and being forced into an alternative between surgery or carrying your pregnancy to term.
But
Increased costs.
they're not forced not to have a non-medical abortion. The rule requires them to maybe travel to do it, because there's clinics in various cities around the state where there can be an in-person examination. So, I mean, that we're talking about a cost thing, basically.
No, because the reality of these women's lives is that they're going to be delayed, and that medication abortion is only available in an extremely narrow window. To put this in context, it's the first 7 weeks of pregnancy measured from before pregnancy starts, measured from the last menstrual period. So most women, from the point they discover they're pregnant, have a few weeks at most in which they can have a medication abortion.
Counsel, your brief indicates that they have to drive to either Des Moines or Iowa City, but hasn't there been a physician available at the Planned Parenthood office in Bettendorf for many of the past years, including quite recently? Could you address that?
Absolutely. As we explained to the district court, because Planned Parenthood is so concerned about access, we were sending a physician to that clinic at a financial loss to try to remedy this problem of access. But that was not financially sustainable for the organization, and it certainly wasn't consistent care. It was only intermittent care at a financial loss that we could not sustain.
Let me ask you, exploring the Ninth Circuit case, Humble, and also Van Hollen, and Judge Posner uses language, something to the effect that you do a balancing test, I think, and on the one hand, you look at the burden.
Yes.
And on the other hand, you look at the safety, and I think he says something to the effect that, the stronger the safety evidence, the more likely the statute to be sustained. On the other hand, as the safety evidence declines, the requirement of burden kind of declines. There's a relationship between
Absolutely.
The two issues. Tell us what the state of the record is on safety.
Gladly, Your Honor. The board justified this rule as medically necessary, but that's completely belied by the opposition of the Iowa Medical Society, the American College of Obstetricians and Gynecologists, which is the leading national women's health organization. They have endorsed this method based on peer-reviewed studies that show that it is equally safe for patients, equally or more satisfactory for patients. And of the 7,000 patients service, there's no evidence of any safety issues that have resulted. And importantly, this has actually improved public health and patient safety because it's allowed women, and these studies show that it's allowed women to have abortions earlier in their pregnancy when they're safer. And it's also actually improved follow-up. So the board cited follow-up as a particular concern. It's clear that under telemedicine, it's easier for women to follow up, so women do that more.
What do you make of the physical examination issue? The board, and I listened to the hearing, the board, some board members at least, and I think it's fair to say, looking at the record as a whole, the board wants an in-person physical examination, and I think it's fair to say puts a high value on that. Why isn't that sufficient to show a substantial interest in safety?
First of all, this court has to ask why the board is so concerned about the physician's physical presence for abortion and for no other service. And the new telemedicine rules that we've directed this court's attention to do not impose the standard on any other form of health care, even though it's clear that abortion is relatively safe. And there are other forms of care that are being provided in Iowa through telemedicine that are equally or more risky. But also, there's no evidence that the physician being present in the room has any effect on safety, and that's what ACOG makes clear. There's a clear standard of care for screening women for ectopic pregnancies. It involves a blood test, a vital signs check, and an ultrasound to confirm intrauterine pregnancy and gestational age. The ultrasound, it's the machine that measures gestational age. The image is transmitted to the physician, whether he's in the clinic or in a different clinic in Des Moines. He reads that image and confirms that this is a safe procedure for this woman. He talks to the woman to make sure she understands the process. So the level of physician involvement through telemedicine is the same clinically. Everything. And also, the woman is taking the second medication, which is what causes the side effects and actually the abortion itself. She's taking that at home, and that's the standard of care that's endorsed by ACOG. That's what women choose to do because it makes the experience feel safer to them and more private and more natural. So she is having that experience away from the clinic, whether or not she goes to Des Moines or whether she goes to Council Bluffs.
You jumped into your argument dealing with the constitutional issues, but what are your thoughts before you run out of time on whether the rule is even proper under 17A?
Absolutely, we think this court doesn't need to reach the constitutional issues because what the district court did here was simply not look at the evidence. The district court said there's a medical study that shows that ectopic pregnancies are a concern for abortion. As we've pointed out, ectopic pregnancies are a concern for pregnancy, and women are at equal risk whether or not they choose to have an abortion. So, and we've actually pointed out that women who come in for early care are more likely to detect an undiagnosed, to detect an ectopic pregnancy than women who are delayed in accessing care. So the board had no medical evidence to support its decision. It was a highly irregular process. It was opposed by medical organizations. Absolutely, for those reasons, it was not, it violated a number of the subsections of 17A 1910.
Counsel, you argued the federal constitution in district court. Why did you abandon that on appeal if you're trying to invalidate this rule?
Because we think that this court should interpret the Iowa Constitution independently, and that this court's jurisprudence is very clear that the federal protection is a floor but not a ceiling for individual rights in Iowa, and that's why we focused on it.
What is the state's interest that we would have to balance under the Iowa Constitution?
The state's interest would be the interest in patient health, which we absolutely agree is a compelling interest, but our point here is that that interest is not served at all by this rule, let alone being narrowly tailored or substantially tailored.
Shouldn't our court defer to the medical judgment of the Iowa Board of Medicine? We went to law school, not medical school.
No, Your Honor, because, first of all, because 17A requires this court to review Board of Medicine decisions just like any other
would
medical.
You agree, though, that under our 17A standard of review, we defer to the board's application of law to fact unless it's illogical, irrational, or wholly unjustified. Is that,
Absolutely, Your Honor. At the
you
same,
contend that standard's met here?
we contend that deference is, even applying that deference, this court should strike down this rule because it has no medical or scientific support.
Was
But
there
the-
any non-advocacy medical group that supported the new rule?
Not to my knowledge, Your Honor.
One question, the board is made up of physicians who we have to believe have some medical training, or else they wouldn't be physicians. And they came to this conclusion, and they were duly appointed, and that was their position after hearing the evidence. I mean, why shouldn't they be given the deference? I mean, the governor appointed them. Elections have consequences, and that's what the governor did. And why shouldn't we just follow the board when we deal with the rules?
Well, under 17A, because that would make this court not an effective check. It would go against the draftsman's report on 17A that says that this is, fairly intensive review, and there's no exception for the Board of Medicine. But certainly, deference is even less of a consideration, or not a consideration at all, with respect to petitioner's constitutional claims. Chief Justice Cady, I see that my time is...
You may sum up.
Thank you. For these reasons and for those set forth in our briefs, petitioners urge this court to honor its own tradition of zealously protecting individual rights, and accordingly to hold that the board rule violates the Iowa Constitution because it deprives women of their reproductive freedom. Thank you.
Thank you as well, counsel. Mr. Thompson.
Thank you, Chief Justice. May it please the court. Context is important, and so I'd like to begin with a couple of comments about context. Over 40 years ago, when the U.S. Supreme Court heard the case of Roe v. Wade, a Texas woman complained that a Texas criminal abortion law barred her access and choice to, quote, choose an abortion by a licensed physician in a safe clinical environment. In finding that the U.S. Constitution guaranteed that right of choice, the court in Roe v. Wade also found in the same case that the state had a legitimate, important interest in the area of health and medical standards.
Counsel, on that point, I'd like to have your reaction to Ms. Chapman's assessment of the record with respect to the evidence supporting the notion that the state's interest in safety makes it important that there be this physical exam by the physician that's authorizing the dispensation of the medicine. What is the evidence suggesting, contrary to what Ms. Chapman said, that physical exam is really important to safety?
Well, I think a couple of things. First, on the evidentiary issue, I do think there's a burden issue here. In other words, without some evidence of burden or undue burden, I don't think, especially in a 17A proceeding, the state automatically takes on the burden to fill the record up. And the record, frankly, is pretty thin. But on this issue, I think it's pretty clear. Number one, the board has made it clear in their comments and their explanations and the reasons that this idea of physical examination first is central. You don't need a study or any data for the medical board to conclude that a physical examination and an in-person relationship between patient and doctor, which is what Roe v. Wade affirmed essentially, is not important to making an informed choice about what the decision is best for you, and to ensure that a physician, which relates to my point about Iowa law, properly assesses the contraindications and whether this person is an appropriate candidate for one of several different methods of abortion.
But wouldn't, if you're going to say a physician exam is needed, why didn't they require a physician exam on an in-person visit? Because I think the record says that they do nothing different if they come into the office and are given the pill, or they do it remotely. So why didn't the rule also require a physical exam on an inpatient?
Well, it does. because this isn't a telemedicine rule. That's the other context issue here. And I think it's also answers both questions, which is the context of this is a drug called RU-486. And there is lots of evidence in the record. You can get on the internet. This is a unique drug. This is not a typical prescription pharmaceutical. And in RU-486 is a two-drug combination for the protocol that was approved by the FDA. The first drug aborts or kills the fetus. The second drug causes contractions and causes the body to expel the remnant of the fetus. The FDA, when they approved this drug in 2000, did something highly unusual. And they created a final product label that included all kinds of stuff. It included a specific stringent provider agreement. In other words, not any doctor can prescribe this. They have to agree and they have to be certified. No distributor can do this without signing a distributor agreement. It actually requires a patient agreement for a patient to get it. And in addition to that, the FDA, in approving the drug based on the clinical studies that were available at the time, specifically provided a protocol for what they were saying was safe and effective use of the drug, and expressly disclaims that they are not finding that the evidence shows safety or efficacy for any other use. And so we start with that from the FDA, and the undisputed fact, that the protocol used by Planned Parenthood of the Heartland, set aside telemed, does not comply with the FDA protocol.
What do you make of the FDA statement in its bulletin in 1982 that accepted medical practice often includes drug use that is not reflected in the approved drug labeling?
Absolutely true. It is absolutely true.
And ACOG, at least, as I read their amicus brief, suggests that the science has moved beyond the 1990 labeling, and cites the various studies and so forth. I know, familiar with all that.
Correct.
So isn't the real question, what's the appropriate standard of care for the delivery of this service?
Yes,
and
it is.
Okay, and so it's not really the FDA labeling.
Well,
If Planned Parenthood complies with the standard of care.
correct. So, but what my point is, what we know is they're not complying with the labeling requirement. They have their own protocol, and their own protocol actually changes other things. The dosing, under their own studies, the choice of dosing that they do actually increases the likelihood of an incomplete abortion.
Your rule doesn't object to the change in dosage, I don't
No,
think.
it doesn't. In fact, our rule.
The FDA labeling in 1990 isn't binding as to the dosage issue today because of advances in science, I
Well,
take
it's not binding on anybody, but the point of the evidentiary question here is that's what the Board of Medicine is faced with. There's FDA approval, there's subsequent information, there's an off-label use, and you can argue about the weight of the evidence. There's certainly disagreement about whether that protocol is appropriate. Other states, you talked about the other federal states, Abbott, DeWine, Humboldt, those cases, states chose to try to mandate the FDA requirement, which would effectively ban chemical abortion after 50 weeks. It would require 3 visits instead of 2. It was much more burdensome. The Board of Medicine didn't do that. What our Board of Medicine did was agree with you that there needs to be a standard of care decision, frankly, in the face of a prior complaint for discipline against somebody that alleged they weren't following the standard of care, and they promulgated a standard of care that focused on safety and trying to resolve these questions, this uncertainty of safety in favor of the woman. And
I have two hypotheticals I'd like to ask you. First, let's assume a woman presents at a distant part of the state, along the border, 100 miles or more, 150 miles, 200 miles
Right.
away from one of the Planned Parenthood clinics.
And closer to Sioux Falls, for example.
Right.
Right.
And instead of being in the office in Des Moines, the physician drives out on location. Everything is done identical to the current protocol, meaning the blood tests that are taken, the sonogram study taken, Everything is identical to what Planned Parenthood currently does, but the difference is that the physician steps into the room and after interviewing the patient, pushes a button and the drawer comes open. Would that comply with the current rule?
No,
Why would it not?
because if I understand your question, and I may not, I apologize, is Planned Parenthood, and the record is clear, I mean, they basically don't conduct a physical examination. If you look
Why?
at the
Okay,
Brubaker
all right.
testimony, and that they use untrained, medical associates to administer sonograms, and they take a history, and that what is required is that there be, the rule requires a physical exam, which is supported by the World Health Organization, the National Institute of Health, including possibly a pelvic exam if it's indicated.
ICOG claims at least, that physicians ordinarily delegate, temperature, weight, blood tests, sonographic studies, that happens all the time.
Sure it does.
And that doesn't mean there isn't a physical examination. The doctor doesn't necessarily lay hands on a person to do a physical exam, I don't think, but you tell me if I'm...
Well, I don't know. I haven't been examined by a OBGYN, but I think that's true. I think that's true. But the point is that all of this, I say context matters. One of the issues here that is in the express reasons for the rule is the fact that under Iowa Code 70773, in Iowa, only a licensed physician can perform an abortion.
Let me ask this question before your time gets away. In reading your brief, you're not really arguing there's no constitutional right under the Iowa Constitution. You're arguing the undue burden rational basis test, as I understand it. I didn't see an argument that it shouldn't be recognized under Iowa, the Constitution, and I haven't seen a state that hasn't recognized it when asked to do it. What's your position on that?
Well, my position is this, is that the state has been before you many times, and many of the cases that have been cited that deal with state versus federal issues involve questions that the state is interested in. And we have argued for the concept that this court should, where appropriate, follow federal standards that deal with common issues. And so it's our view that it would, you get to decide, frankly, but if you decide to do so, that you could do so based on the federal line of decisions, beginning with Roe v. Wade, and if you do so, therefore, under your own analysis about whether you then follow the rules or own rules or apply the federal standard with teeth, under these facts and these circumstances, should adopt the Casey framework.
But my question is more basic than that. My question is, you're not saying there's no right for a woman to seek an abortion under the Iowa Constitution. You're saying that the right is there, but it's coextensive with the federal law, the way I read your brief.
I think that's right. I mean, the point is, I don't get to declare what the law is under the Iowa Constitution, and to date, you haven't done that. And what I'm trying to say, as carefully as I can, is that you're entitled to do that, but if you do that, consistent with what we've told you over and over again, that you should look at the federal guidance, especially...
Saying we should, you're not making the argument there is no right of abortion under the Iowa Constitution.
No.
Thompson, on the undue burden test, is it partly an issue of what's your point of reference? Because if the point of reference is the situation just before this rule was adopted, the Planned Parenthood seems to have made a showing of burdens. On the other hand, if your point of reference is the situation prior to this practice that apparently is only occurring in 2 states going forward, then we're talking about simply restoring the situation to the way it was before 2008. So what's the state's position on the frame of reference for the undue burden test?
Well, I think the frame of reference is we have to look at the rule and to see whether it imposes an undue burden under Casey. And the rule, although not a telemedicine rule, it deals with standard of care about performing a medical abortion, would effectively prevent a doctor from doing it the way they're doing it. So I think that that's the proper framework, but one of the, I guess the premise to your question is that if we kind of look at before and after the rule, that somehow that's going to be obviously burdensome. But one of the most interesting pieces of evidence in the case, and there's not much, frankly, on burden. There's virtually none other than kind of a parade of horribles and affidavits. I mean, there's no data. I mean, Planned Parenthood, App 416, put a study in the record. It's a Grossman study, and it's the only real hard data. They talk about the Washington rural study that's in the mountains of Washington. They talk about other things, but read this study. If you do anything on burden, read this study. It shows that they studied 2 years before they started telemed and 2 years after. And what it shows is there was no huge unmet need, number one. Patients didn't drive shorter distances, number two. And in general, it had no real impact. And in fact, this is Grossman. This is their person. And I don't want to talk about all the nuts and bolts because I'm going to run out of time. But at page 420, here's what they say. Despite this apparent improvement in access to abortion care, we observed a relatively small reduction in the distance women traveled from their home to the clinic. Although this finding may seem surprising, distance to the clinic is only one of several factors women consider when choosing where to obtain an abortion.
But that study, they were sending doctors out in the old days, so they were driving to those local clinics.
No.
Yet, according to what Planned Parenthood testified at the hearing, not the study, Planned Parenthood said before they did telemedicine, they were sending doctors out to these clinics to do it. And the study also shows, does it not, that the results of complications, whether by telemedicine or whether not by telemedicine, were exactly the same.
They weren't worse.
Actually the same.
Right. I mean, so they weren't worse, but they weren't better. But I do think, I mean, it's worth a read because the numbers look at a 2-year period before telemed, a 2-year period after, and in the end, it does the total change in the mean distance traveled of people who they actually treated, it was a reduction of 3 miles. And if they looked at everybody, in the end, you know, it had really no effect on people who lived more than 50 miles away from their
Again, that's with
clinic.
sending doctors out rather than them driving to the clinic
No,
because the doctors were at the clinic.
No, I think the 2-year period is how they used to do it, driving to the clinic. The second 2-year period is during telemed. So
That
it's the
study
change.
seems quite inconsistent with the geographics of Iowa, doesn't it?
Well, it sure does. It certainly seems inconsistent with the arguments that are being made. But this is their own study that they put together in order to prove their undue burden claim. And it's in the record, and it doesn't.
All right, other than that study, is there anything that has changed since the rule permitting the teleconference procedure was adopted by the Iowa Board of Medicine in 2008, other than the makeup of the Iowa Board of Medicine?
Since
What other evidence can you point to that's different from the first time the board took this rule up?
Well, they didn't. They've never taken this
Well,
rule up before.
when the procedure was permitted to be done.
Well, and again, I see that's what the board
What's
faced-
different since this all started?
Well, nothing other than this rule provides a standard of care. The prior complaint in 2010 was an allegation of a violation of a standard of care that didn't exist. So what this rule does is fill that hole and fills uncertainty for doctors, uncertainties for Planned Parenthood about what complies with Iowa Code 707 that requires doctors to perform
Wait a
an
second, the
abortion.
standard of care did exist in 2010 because the ACOGs had the standard of care. And if you go before the Board of Medical Examiner and they claim that you didn't comply with the standard of care, the Board of Medical Examiner doesn't have a standard of care for every procedure every doctor does in the state. They rely on the standard of care generally used by practicing physicians.
True.
And when some physician testifies before hearing, I do it this way, that's not the standard of care. a physician has to testify that's the accepted standard of care for it to be accepted, as I understand it. And there's no evidence in this record that I could find where any physician testified that the standard of care that's accepted around the country is an in-person examination.
Well,
Now, one
there
physician
is.
testified he did it, but he never testified that's the standard of care, and that's a big difference.
I mean, there was a doctor that testified at the open hearing who followed Mr. Brubaker. After hearing Mr. Brubaker say, we don't generally do a physical exam, he came next, and he said he was OBGYN board certified. He said, that is not the standard of care.
That is not what he said. He says, I do that, and it's important to do it. The standard of care has to be recognized by physicians around the country, and I think the ACOG is probably in the best position to tell us what the
Well, they
standard of care is.
changed theirs. I mean, the record is clear that they changed theirs as well. And so one of the things that the Gonzalez case says under the U.S. Supreme Court line of cases is that in the face of medical uncertainty, which is what we have here, their argument is if uncertainty happens, then you can't regulate. What the U.S. Supreme Court has said that actually regulators have a much broader discretion to regulate where there is uncertainty because the goal of standards of care and legislation is to resolve uncertainty. And that's what this standard of care does. It's necessary. You may not agree with it. I may not agree with it, frankly, but it's within the authority of the Board of Medicine to do this, and it is absolutely constitutional.
One
under
other
the Iowa
question
Constitution.
before you leave, and I'm sorry to go over here, but is there any other rule or regulation in the Board of Medical Examiners rules and regulations that set forth the standard of care for any other procedure or any other practice of medicine that you're aware of?
Two that require physical examination.
No, I'm talking about other procedures. Do they have a procedure for neurologists when they examine somebody, or for when family doctors examine somebody? Is there any other standard of care such as this contained in any rule or regulation of the Board of Medical Examiners that you're aware of?
Not that I'm aware of. Thank you.
Thank you as well, counsel. Rebuttal argument?
I'd like to clear up a few points of confusion.
Follow up on that last question to Mr. Thompson. Are you aware of any other medical procedure in Iowa that by statute has to be performed by a physician?
No, Your Honor. We've pointed to pain management where the board does require physical examinations, but the point we've made is it's very clear in those requirements that it doesn't have to be by a physician. So no. I'd like to clear up this question about this.
You agree that in 707 of the code it says that an abortion has to be performed by a physician, right?
Yes, that is a law that's been on the books since the 1970s, long before safe medical non-surgical abortion was available. On this question of the published studies and whether they show a burden, what my colleague is leaving out is that the reason why there isn't a large difference in the distance women are traveling, comparing before and after the telemedicine program began, is because more women who live more in these rural areas, more than 50 miles from a provider, have been able to have an abortion under the telemedicine program. So the important fact is more of those women who live further from centers of care are getting this abortion care. And that's why the miles may not change so much, but the really important fact on burden is that more women are able to access this care. Also, the studies show that significantly more women are having this care earlier in their pregnancy. They clearly show that this telemedicine program has significantly reduced the incidence of second trimester abortion.
What's the state of the record that before you were allowing or providing telemedicine abortions, about physicians actually going out more rather than being able to do it?
The state of the record is that that Planned Parenthood was sending physicians to at least, I believe, 2 outlying clinics on an intermittent basis to try to provide some care to those women, but there were scheduling problems, and the studies show that they were having a lot of trouble fitting women in when the women needed to come in. I'd like to talk about the FDA protocol for a moment, because it is not unusual for there to be a medical guideline in a manufacturer's FDA label. This is not some special thing that the FDA did here. The manufacturer comes up with the protocol. They test that protocol. They submit that protocol to the FDA. So this is not as unusual as my colleague would suggest, and nothing in and this is not a requirement on providers, as I believe Justice Wiggins, you pointed out. Off-label medicine is a widespread and accepted, sorry about that, a widespread and accepted practice.
Yep, thank you. To recap what I understood Mr. Thompson to say, and maybe embellish on it, but he suggests, well, the telemedicine is certainly relatively new, and I think we all agree with that. The standards are evolving somewhat, and the ACOG came out and maybe started out in 2005 and then 2013, if I have the dates right. But I mean, it's all relatively recent, and the board is risk adverse and thinks, well, there's some recent interesting developments, but you know, we don't think there's enough science out there. We're just going to be risk adverse on this issue. So I think that's an embellishment of what he said. But go ahead and respond to that line of argumentation.
Sure. First of all, I would argue that telemedicine is not new in Iowa. It's been around for decades, and so it's not some new experimental thing that it would make sense for the board to be risk averse about, particularly when it's coming out with new telemedicine rules that recognize, and the comments to those rules made clear, this is happening all throughout the state. Drugs are being prescribed without an in-person visit, and the board is okay with that. That's reflected in their revised rules. But also, medicine evolves, and the new protocol, which is different from the one described on the manufacturer's label from 2000, is, contrary to what my colleague said, is more than 4 times less likely to require surgical follow-up. The new protocol is vastly more effective than the one submitted to the FDA in 2000. That's the nature of medicine. Telemedicine advances are medical advances for patients, and there's no reason why women and pregnant women should be singled out and denied medical advances regardless of how risk-averse the board is. And these are advances that have been demonstrated to improve patient safety. Not every form of telemedicine in the state is the subject of peer-reviewed studies and analysis, as this one is. I'm glad that my colleague mentioned the prior complaint. It was not by a patient or by a medical group, it was by Operation Rescue, and it's very important in this case because the board itself undertook an intensive investigation of that complaint in 2010 and found that Planned Parenthood's practices were safe and could continue.
Well, is that, really? What does the record really show on this investigation? I mean, you're absolutely right that there was a complaint and so forth. And it is true that the board took no action, as
Right.
I read what seemed to be the decision letter.
Right.
But what I'm not sure we know, and please correct me, I'm not sure we know exactly what happened between the complaint and the letter.
We have the statement from I believe he was the chief medical advisor at the time, John Olds, that the evidence that Planned Parenthood presented to the board was compelling that its program was safe. We also have the fact, as you're pointing out, that the board took no action. It had the discretion to issue a warning letter or an education letter to Planned Parenthood to request modifications, and it did none of that. And it has the statutory obligation to act on complaints if there's any safety issue. I also finally just want to address this issue of whether you need the physician in person because women are making a difficult decision when they come into the clinic. First of all, this rule does not require that. The board has never before suggested that that's a rationale for this rule. And it really makes no sense because Planned Parenthood has trained counselors who talk to women about the decision they're making and their other options and make sure that they have fully thought through their options before they do reach this decision. The rule doesn't change that. So it really, that rationale really can't be used to support it here. Finally, I want to say that there's no evidence. My colleague referred to the professionals who perform the sonograms and these procedures as untrained. Actually, Nurse Buckaker testified extensively to the board about their training and the fact that they are continuously monitored, and the fact that the physician reviews the ultrasound, and if there's any problem with the ultrasound, it's within the physician's professional judgment, and that's how this is left, in every other area of care, to make sure that that sonogram is adequate. Thank you.
Thank you as well, Ms. Clapman. The case then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.